call the meeting to order. So this is the meeting of the subcommittee of the Ethics Committee of the State Bar, and members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest, and are instructed to refrain from participating in any matter coming before the committee with respect to which there is a conflict of interest. Does anybody have any conflict that they feel should be noted? No. Right. And did you get the pop-up reminding us that this is being recorded?
Yep.
Okay. So no cussing, Warren.
I'll be on my best behavior.
Brian, can you?
But you all look so pretty.
Thanks, Warren.
Can you update us on who's on the committee now, the subcommittee now? Because I know, just to recap, we ended the year. I am not going to be on ethics next year, but I understand, just to confirm, I'm going to continue chairing this particular subcommittee just so we can finish out what we started, but I don't know where everybody else stands.
That's right. So we're still, I guess we're still in the process of getting the final lists of the appointments and the different committee assignments, but I think we're kind of 99% there. And yes, Andrea, you have been asked to continue in your role as chair here of this subcommittee. Our new chair of ethics, Catherine Fry, has reappointed everybody to these committees, all existing subcommittees, including any appointees advisory members that have rotated off or anything like that. So the advisory members are what we're kind of finalizing right now. I do believe that the last draft that I saw, Stacy and Christina, you're still on it as advisory members, so you're going to have to put up with me for another year. And I apologize for that, but nevertheless, we'll continue working in this regard on this one until it's done.
Okay, and so what about, I don't see David and Judge Bell on this. Are they not participating?
I don't think Judge Bell was able to attend. I thought David was able to attend, but he may have had something that was scheduled for today, and it was kind of a tentative participation. All right.
I'm sure if he has a chance, he'll jump on. So,
oh, and actually, Andrea, I just received an email from David saying that he's still on a call that started at 2 p.m. He's going to join if he can. This is what he says is his swan song because he's moving to grievance as well next year. But little does he know he's going to be stuck on the subcommittee until we're done as well.
Okay.
So.
David Allen's going to be on grievance. That's
Can
hilarious.
you believe that? Those meetings have now been scheduled from 8 a.m. to 4 p.m. Nothing but love, David.
All right. So Brian, if you can just kind of recap, I guess a few things. I'm going to give you kind of my list of what I would like to get from you today. First, if you can recap what in your mind you think we've accomplished so far, where we left off last time. I know you've done some work. At one point, I would like you to go over all the changes you made and explain them, see if we have any questions. And then at the end, with your blessing, we'll figure out what we have left. So you don't have to do that all at the same time, but those are the things I want to get out of you.
I think that's great. It's a great way to start. So yes, as far as, and here comes Missy right now. As far as what we've accomplished, I think our last meeting was very productive. I went back and watched that video back again, actually twice, and just trying to make sure that I'm capturing all the conversation. And really the focus last time we have a lot of different inquiries here about the sale of a law practice and how we handle old files. But we recognize that there's an opportunity for some instruction, whether you're selling your practice or simply retiring. closing the practice. Maybe that's something else that we need to approach. And I'll tell you, Andrea, there is something that for whatever reason, it just occurred to me this morning of, my goodness, this would be a great way to wrap up this opinion that focuses exclusively on closing the practice. And I drafted a new part of it today, and I'll share that with you all shortly during this meeting. But really, we focused on the concept of notice. We had a lot of questions with the first draft, and this issue that lawyers are supposed to notify their clients when they sell their practice, they transfer files to another person, transfer representation to another person. There's slightly different requirements for whether you're just transferring information versus transferring an active representation. But they all really kind of start with notice. And we talked a lot about what sort of notice is required. Is it actual notice? And we concluded that it's not actual written notice, but it is basically notice that is provided with a lawyer's reasonable efforts. That we recognize some clients are impossible to locate. Some clients you lose touch with. And so a lawyer needs to make reasonable efforts to notify those clients that they're transferring their files to a subsequent attorney, things of that nature. We started talking about these questions of, well, we've got client files, but then you have some client files that have really important documents. We call them original documents of legal significance. And this term that has been referenced in our prior ethics opinions, but has never really been defined. But we talked about just what does it mean to have a document of legal significance that really kind of takes the identity of client property, something that a lawyer can't just throw away, or certainly the client would deserve to know where it is should the client retire, sell their practice, and move away. Things like a will, power of attorney, etc. And so I felt like we were looking at those two issues and trying to get on the same page. And I think we got on the same page. I saw in that meeting, we had a lot of good conversation, I think a lot of agreement. And that's where we are now. The opinion that I emailed you all on Friday tries to really capture our discussion and our conclusions. And I think to that end, it might be easiest if I just share my screen and we start going through, and I can just kind of outline where we are in this opinion, what I did, so we can all be on the same page. Is that all right with you?
Yeah, that would be great. Thanks.
Okay. All right. So here we go. I'm sharing my screen now. And this is where we start getting into the background, of course, as you all know. We're talking about lawyer being a solo practitioner, selling the practice, and so forth. We didn't really have an issue with inquiry number one, basically this question about, well, is lawyer B an appropriate person? And this is really, it's the purpose of this first inquiry is just to provide kind of a general reminder that folks, if you're going to sell your practice, you shouldn't just sell it to anyone. If you're a criminal defense practitioner and you're trying to sell your practice to somebody who's a real property practitioner, that might not be the best thing, because you still have a duty to your clients, particularly those ongoing current clients, to basically, if you're going to transfer their case over to somebody else, that person is competent to handle those cases. So there's a requirement of competency. It's not just sell it to the highest bidder, but there is a reminder there for who we're supposed to sell it to, an appropriate person. That wasn't really a controversial thing. Opinion number two talked about this 100-mile radius, which is still in the opinion. And I remember from our last meeting, we didn't really like this 100-mile radius thing. It just feels a bit archaic, a bit arbitrary, and that's where we are in a spot. I think there is a general desire or interest to potentially amend the rule with regards to this 100-mile radius. That's in Rule 117, and I think that is on the table. What I think is the best thing to do, though, at least for this opinion, is to recognize what the rule says, and kind of the rule is what it is. But if we want to pursue a rule amendment, I think that would be something that perhaps comes from this subcommittee, a recommendation from this subcommittee, that goes to the full committee, and we get a sense from the full committee that, yes, we should go with the rule. I don't know about having a prepared rule to just kind of come out of the blue and say, we have a new rule for you all, take a look at this. But I think it'd be more appropriate to get a sense from the full committee of whether they think that 100-mile radius is archaic and unnecessary. But again, the opinion remains the same because that's what the rule is, and the opinion is not really a place to change the rules. It's a place to interpret the rules. So that's opinion 2. Opinion 3 is where we start getting into the issue of notice. The question being, written notice of the sale, who does it go to and what type of notice are we talking about? And I tried to make some changes here that clarified exactly the foundation for this notice requirement under Rule 117, but then got into this question of what type of notice is required. And this opinion that starts what constitutes sufficient notice. It was my attempt at capturing our discussion from the last meeting, when it basically says that what's going to be sufficient notice really depends upon the circumstances regarding the information that's available to the lawyer. If you have a client's email address and you send an email and the email doesn't bounce back, maybe you've communicated with that client in another matter, email should be sufficient notice. The rules do not dictate that notice must be mailed or that it must be, sent certified, return receipt requested, anything like that. It just says notice. And so I think from our conversation, we were talking about, like I said, reasonable efforts that need to be made. If you have an email address, if you have a mailing address, if you have the best information that you can find and you try to communicate using that information, and either you're successful or you have no reason to think that this information has changed. You get no indication, like a letter that gets returned, an email that gets bounced back that basically tells you your prior attempt to communicate with this person was unsuccessful. That's reasonable. Those are reasonable efforts that a lawyer needs to make to notify the person that their information would be transferred via the sale of a law practice. Remember, we're still talking about transferring information, different from transferring a representation through a current client, which gets addressed in a later opinion. But this is just focused on information. If you're transferring information to a new lawyer, then you have to make reasonable efforts to provide that notice. There's also, I have a footnote in here that tries to explain, there's a part of the rule that basically says, if you send that reasonable written notice and the person does not object within 30 days of receiving that notice, that you can presume their consent to the transfer exists. Well, you've got a problem with 30 days within receipt. And I think based on our prior conversations, we don't think it's reasonable to require people to have, certified mailings and all that, and to actually prove that the person received it. So I added a footnote that clarifies, that again, when receipt may be presumed to occur, that triggers that 30-day period is going to be dependent upon the method of notice. Like email, as an example, you send an email, it's a working email address, it doesn't bounce back. Then you can presume that notice was sent and it was placed in that person's inbox on the day that it was sent. If you mail notice, I borrowed from the rules of civil procedure, saying that you have an additional 3 days usually added on when you send something by mail under Rule 6, and so said that basically presume that receipt occurred 3 days after you deposited that in the mail. So it just trying to kind of, again, tie up a loose end if people say, well, how am I supposed to calculate that time? It is going to be, kind of dependent upon how you actually communicated that notice, that written notice. But again, this opinion, I think, is kind of one of the key ones to our conversation, that notice really is accomplished by a lawyer making reasonable efforts to reach out to these individuals. So I'm going to just keep on going through these because this is where we start cascading here. Inquiry number 4 basically kind of asks that question. Okay, so now I've made reasonable efforts to send this notice. and nobody objected, or my client doesn't object, can I send the client's information over to lawyer B just to make it abundantly clear? Can you do that? Yes. If you made reasonable efforts to send that written notice, then you're good and you can transfer that information. Inquiry number 5 takes it to that other question. It's not just transferring information. Now we're talking about transferring an active representation. That's the distinction that the rule makes. And so we want to illustrate that lawyer has made reasonable efforts or taken reasonable steps to notify an active current client that the sale or the practice is being sold and that their information, their case is going to be transferred to lawyer B. Upon making those reasonable efforts, can you transfer the active representation? No, unless you get the court order. That's where Rule 117E comes in, saying that because you're dealing with an active representation, there's kind of an extra step that's required to protect the interests of a current client with a pending matter. That is, that the representation isn't just presumed to be, I guess the transfer of the representation isn't a presumed consent situation. You can, it's like you're almost building toward it, but you ultimately need a court order that authorizes the transfer. I kind of look at that as it's the court that's authorizing transfer the switch of counsel, as well as authorizing this new lawyer to look at ongoing active client matter, which is supposed to be confidential. So it kind of, just kind of recognizes, again, there's a difference between transferring information versus transferring an active representation.
And can I ask about that?
Yes, sir.
And you mean that's for any type of representation, not just litigation or criminal defense or family law that's in court. You mean, if I'm preparing sales documents for a closing, if I'm doing contract drafting, if I'm doing anything where it's an ongoing representation, you're still going to have to get a court order.
I think the ongoing nature is, it's kind of this, I guess I'm drawing a distinction in my head of like, I have a lawyer that's on retainer in general.
Right.
And I don't think the rule is really applying to that situation. It's more of like, I'm actively attempting to complete a task for you. So I'm in the middle of drafting and negotiating a contract with opposing party. And now I'm selling my practice and I'm retiring and I'm getting out of it. And I, for whatever reason, cannot reach my current client who I've been talking to about this representation. I think that's what they're like. It's going
to be rare.
It's going to be very rare. I would think it's very rare, but I do think that the reason the rule distinguishes that is because the extra protection that's needed when you have that situation where you're saying,
right,
I, lawyer, can't get in touch with active client for whatever reason. No clue.
If I can interject.
Yes.
I'm thinking of a situation. I've got some transactions that go on for a year or more, 2 years even, and I may not be in touch with my client on a regular basis throughout that period. So I think there's also that kind of scenario. It's purely transactional. There's no litigation involved. There's certainly no court to appear before to ask for a release. But there are transactions that go on for significant periods of time that a lawyer shouldn't be obligated to stay involved for just however long this continues. So I just want to throw that out there because I think we're not taking into consideration something like that.
So in that situation, like if you're involved in a transaction that's taking years, even if you're not keeping in touch with the client on a regular basis, would you lose touch with the client such that you could not contact them and say, hey, I'm selling my practice, I'm retiring, I've got a new lawyer that I'm transferring this to you, but you can go your own route, go with this person, whichever one you want. Do you lose touch with them?
I think it's unlikely. I think probably what would be more likely is a client who probably abandoned the transaction and didn't bother to tell their lawyer.
Right.
But we do have transactions that can go on for years, and so I just didn't want that to be overlooked in the analysis.
Yeah, and I think and tell me if you're uncomfortable with this, because I think the analysis tries to say that essentially, if you can't get in touch with your client, you can't provide them with that notice that the transfer, the sale of your practice, transfer of representation, absent the client's knowledge and involvement, can only occur through a court order. And when you're dealing with a transaction of multiple years, I guess I would think that would come up very rarely, where you really cannot get in touch with your client and say, hey, I'm going away, you're going to this person now. That I guess that's the harm that I'm wondering if we're hitting on that issue.
It might be equated to having to get when you get a state bar trustee appointed for a lawyer that dies or becomes incapacitated, you got to get a court order for that trustee to be able to look at all the files and do what they need to do, and whether they're in court or otherwise. I mean, you're not getting a trustee in this case, but it's the similar sort of scenario where before somebody else can look at the file and do anything for the client, they got to get a court order.
Well, and I think it's also before the new person can look at the file, take the active role as like the lead counsel without the client's input. I think that's what I've always interpreted that rules requirement to be.
Right.
You don't have
I will say, from a risk management perspective, that if you are acting on behalf of a client who hasn't given you authority ahead of time for an ultimate objection in something that's ongoing, and now you can't get in touch with them, you're probably you're constructively terminated at best. And
I mean, there's still the option of just withdrawing from representation,
right. That's where I think I always saw that rule. I think you're right that the rule really, it's most applicable to the family law, the criminal law, that type of representative. There's active litigation. Transactional matters like this, like we're talking about, are kind of swept in because the rule doesn't distinguish between the type of practice. It's just kind of saying, if a client's not involved and they're getting a new lawyer through the sale of the practice, then you got to have a court that basically gives an okay. I'd like to think that would be very rare in transactional matters, because you hopefully should be able to get in touch with the person if it's an ongoing active client. This isn't former client, this is only current clients, even if it's a transaction that's taking that many years. So I don't know, Christina, is that still like kind of uncomfortable or not appropriate, or what are you thinking?
I'm just wondering if that maybe that we can specify, I don't know, distinguish between those matters which are litigation matters versus some kind of transactional representation, where it wouldn't be a matter of just making a motion to go before the court with jurisdiction. Seems like the rule makes sense in a litigation perspective, but it really doesn't seem to apply to something or fit as well for a transactional type matter.
I have a question, Brian, or maybe Warren. Do either of you know what the actual procedure is in getting a court order? I think we talked about this last time, where there's a rule, but it didn't sound like you had to actually file a lawsuit. You just had to get a judge.
Like a petition. Almost,
I was going to say that, like, the petitions that the bar files to appoint a trustee, usually depending upon the county, they can be filed as different things. They're never filed as civil matters like CBS. They're usually filed as R files. I've seen R files. I've seen M files, kind of the R, the record files that they have. And that's been the most common thing whenever I've had to appoint a trustee. So they do have a process by which you can petition for the appointment of a trustee, or I think you'd petition the court for the transfer of the representation, kind of outlining, I have an active client. For whatever reason, I cannot get in touch with this person, but I got to go. And I need this person to step in and take authority in the client's matter, despite the client not giving that authority to the lawyer. And that, I think that's kind of it's the awkward position that the new lawyer's in. I mean, a new lawyer might say, if you can't get in touch with this person, I don't want that client.
Yeah, that's exactly right.
Yeah, but to build on what Christina said, like, and what somebody else, it might have been Warren who mentioned it, but in litigation, it's actually less of a problem because of the opportunity to withdraw. So it's really going to affect more the transactional people, attorneys, the way I see it, because if you're trying to sell your practice or close your practice down and you're in the middle of litigation, it's easy. You go to court and you say you want to withdraw because you can't get in touch with your
Correct.
client and you're out. But it's the transactional situations that Christina described that I guess we just need to make sure that we understand this.
I guess that's where my idea or my point was that if you're constructively discharged, you can't hand it off to somebody else anyway. If the client is not communicating with you and has gone off the reservation and hadn't given you advanced, authority beyond hiring you, then you can't do anything. And so you can't give them to somebody else in a transactional setting and give it to another lawyer and say, act on this client's behalf who you've never even met, let alone have any authority for. I don't see how that could happen.
So from a practical standpoint, Brian, if we have to go get a court order for a file, like I'm just going to build on what Christina was talking about. You have this transaction, you haven't had contact with your client in a year, let's say, you send a letter, you get no response, you do your due diligence, you make your reasonable efforts, nothing. If this rule says we have to go get a court order, from a practical standpoint, what are we asking the judge to order? Are we asking the judge to say, yes, you can move that file to the new attorney? Like, what happens to the file?
Yeah, I think that's exactly what it is. You would petition the court to transfer the representation from lawyer A to lawyer B. And that's kind of what we do with those trustee orders. When we have a trustee appointed that is stepping in and looking at client information, that like the trustee is typically not appointed to take over the representation, but they are empowered to take, kind of procedural steps. They need to request a continuance, et cetera, but not, and also just look at the client information, the confidential client information. And so we just ask the court to approve this person. I guess you're asking the court to approve lawyer B as client's new lawyer, and permitting lawyer A to essentially step away, kind of wash their hands of it, which is a significant thing because client retained lawyer A, and lawyer A presumably has that responsibility until discharge. But they're actually walking away from it and shifting professional responsibility to lawyer B. And that's where they're saying in that, what I consider kind of a unique situation of a current client who you cannot get in touch with, you're actually transferring the representation to another person. A court has to give the okay, which I think really serves more as a cover for the attorneys, as well as a slight protection for the client. But I mean, the court doesn't necessarily know, whether or not the client really is okay with that. I think the court just is that third party that looks at it to say, yeah, I think this is reasonable, and it really gives the cover for the attorneys to execute.
So based on what you just said, Christina, and I'm going to direct this to everybody, Warren, Stacy, and Missy, can you live with that, or do you want to work on this a little more? Maybe not at this particular moment, but we can flag it to come back and work on it. Are you comfortable with what we just described?
I would like to have some more time to consider this one.
Okay.
Just to process. Maybe I'm just not thinking of everything, correctly. But I'm just thinking about, okay, well, should we offer the opportunity to say, you can withdraw from representation, but then what do you do with the file? I wonder if we should throw out some additional alternatives. I don't know. Most of us transactional lawyers kind of panic when you suggest we get in front of a judge. So
How would you withdraw? How would you withdraw from representation? Like, I mean, you can send I guess you can send a letter and say,
Yeah.
I'm not representing
Yes.
you.
I think that's,
And our engagement letters, permit us to do that,
Yeah.
to withdraw
couldn't
from.
couldn't we put in here just some sort of short sentence that says, if you can't find your client, first analyze whether you should just withdraw rather than try to transfer this file.
Yeah,
Yeah.
I think that's what, Christina, to your point, I think that's kind of the instruction that
Yeah.
we're offering, the guidance here, that we can say,
Yeah.
it may be most appropriate if you cannot locate your current client to inform them of this and
Right.
transfer the representation. Another option is to not go forward with transferring the representation. The option is just withdraw.
Where does
Withdraw,
it say that, Brian? Where does it say that in here?
No, it doesn't say that. I think we could add that. Maybe
I would move to add that.
Yeah.
I agree.
I like that.
I
Okay.
like that too, because it's also, and you can refer, there's a ethics opinion on when you should consider yourself constructively discharged after
Right.
taking, reasonable diligence to try to locate a client and they're out responding, then you can't act on behalf of them any longer. I think it's the one about whether you can file a complaint on behalf of a client who's hired you a year before you, or 2 years before you, the statute was about to run. Now the statute's coming, you can't find them.
Right.
And can you just go ahead and file a complaint for them? And the thing says no.
Yeah.
Unless you
Yeah.
have specific authority to file that complaint, you got to find the client and do it. And if not, you are constructively discharged and don't file that complaint.
All right. I'm going to add that, it'll still have the, kind of the general notion of like, yeah, we can withdraw. Rule 116 talks about withdrawal and, the steps that we need to take to protect the client's interest. And I think that's where, to your point, Andrea, we're talking about really, we've already built in the steps that are necessary to protect the client's interest in this opinion. You're giving them reasonable notice. I'm no longer going to be doing this. You're trying to get them to move on to counsel. You're offering them an opportunity to get their file and all that stuff. At some point, there has to be an opportunity that you either transfer it to somebody else, but to do that, you need the court order, or you withdraw. And it's just not made a part of the sale of the practice anymore. So I'll add that provision in here. I think that's a
Yeah, I like that. I like that.
Okay.
I was just going to say that most our fee agreements have, if the client is not participating and not communicating, then we withdraw. So most of my case, I do have this exact situation right now. It's an ongoing litigation matter and we can't get her to respond. So we filed our motion to withdraw, but it's before the court. And
Right.
I think y'all's concern is more with transactional. So who knows, when a lot of debtor clients sometimes just put their heads so deep in the sand, they don't respond sometimes. They don't want to respond.
Yeah.
But I think that with that added provision, that makes it clear, just don't transfer it, just withdraw.
Okay. That sounds great. Thank you all. That's really helpful. Okay. So the next opinion basically talks about, excuse me, whether or not you need to, it's that very simple, straightforward. Do you need to send notice to basically former clients whose information you don't transfer? The answer is no. You don't have to send notice to every single person you've ever interacted with. It's only the people whose information is being transferred or representation is being transferred. I reorganized here and I put as the next opinion or the next inquiry after this question about, all right, well, what are we talking about when it comes to essentially client property, documents of legal significance? And this is where I tried to define the term. I am certain that you all can help me define it better. So please know that there is no pride of authorship here. I was looking around for any other jurisdiction or authority that defines this term. And I've seen this term used multiple times, but nobody has defined it. So so here's our attempt. By all means, I'm happy to talk about this, but again, this question. It's kind of that next level or the next step of the question. We were talking about transferring information to a new client or to a new lawyer. We dealt with transferring an active representation to a new lawyer and what the options are there. Can we deliver client property to a new lawyer? That's kind of this purpose. And really, we're talking about client property in the form of documents. And I know that's the sort of thing that, I would like to think that, there isn't somebody with just like all this these pending entrusted funds sitting in a trust account. And maybe that needs to be a different inquiry, because anytime that somebody's called me and said, I'm trying to close down my practice, I'm selling my law practice, what do I do with these lingering funds? I tell them it's cheated. It's cheated. Don't send it to the new lawyer, because now it's the new lawyer's problem. Just escheat it and be done with it. And maybe that needs to be something added here, because really the purpose of this one, we're talking about, like I said, these documents that become property due to their inherent value, the materiality of their existence for the purpose of achieving the client's representation or the goals of the representation, namely wills, powers of attorney. Estate documents are the most obvious sorts of documents. I tried to talk about, some of the things we talked about last time. A contract. If you have an original contract, an original executed contract, is that legally significant? And I think maybe it is for a limited period of time. I put in here that if it's still in the process of being carried out, that it's I would say you're the only copy that evidences this agreement. I think you should probably keep it. If the contract has been carried out and it's no longer a thing, there's nothing left to enforce, then that loses its legal significance. And then I also specifically called out client files that stem from real property closings. That real property documents, I feel, I guess personally, and I also feel like amongst this subcommittee, that we don't see those as original documents of legal significance, because they, there might be some originals in there, but they don't have that legal significance in the sense that property has been transferred, the deed has been recorded. There's no material need to keep those documents for the purpose of achieving the client's goals. Those goals have been achieved, they're done. So I tried to use those as an example of documents that are not legally significant for this purpose, for this inquiry.
So Brian,
let's maybe start there with like this definition.
okay, so I dabbled in trying to come up with a definition, and it's
okay.
Just a different perspective than what you did, and mine doesn't need to be exhaustive, but I just want to know what you and everybody else thinks about it. That a document of legal significance would be a document the absence of which could cause harm to the client.
I think that's, I guess I look at that as like kind of really the kicker. That's the key thing. If you don't have this document, it harms the client. Now I know that there's sometimes we can all be lawyers here and start nitpicking of like, well, what do you constitute harm, and who's determining the harm and all that. But I think that's where I was focusing on what are the goals of the representation? The goal was to document how I want my estate divided. And if that document no longer exists, then my representation, the goal of my representation has been completely thwarted in that regard. And that's harm. And that's, I think that's, to your point, Andrea, that's the thing we're trying to protect against, client harm. So
you go ahead, Warren.
I would like to qualify that to some degree to make sure that it's a document, the absence of which you either didn't already give it to the client, or, I can see the client saying, well, it's a document of legal significance if I threw away the copy you gave me.
Yes.
And now you have the only copy, and that can be true of a whole lot of documents.
But I thought we were talking about originals here. Like,
Yeah, I guess, but you know, what original of a contract, that's great, but most contracts can be proven without the original. I mean,
Well, I
hell,
guess I'm thinking, even to your point, Warren and Andrea, like people, I know some folks have had clients execute 2 original wills.
right.
Lawyer keeps one and they give one to the client. And to your point, Warren, like if client's like, well, my lawyer's keeping this, I'm throw it away. The legal significance has increased for the lawyer without the lawyer knowing.
Yeah,
You know,
I guess
so
that's kind of my point.
yeah, and I agree. I feel like if a lawyer provides a copy to or an original to the client, I mean, frankly, I hope that one of the messages here from this client or from this opinion is, you know, send those originals with the client.
Always.
Let's do that, but it kind of remove lawyer from the equation. You know, do they have a backup copy that would potentially need to be submitted for probate and, like, you know, have litigation about it and all that, although it's not the best copy, all that stuff. I don't know, but the point being that I think if we put in here, and tell me if you all agree, some notation that if a lawyer provides an original document, if they have 2 originals, they have duplicates. If you provide it to the client, then lawyer can presume that their retained original is not legally significant.
I like that.
I think absolutely on that.
Okay.
Once we give originals to clients, we should be absolved of having a responsibility to keep our originals.
I like that.
So just a couple follow-up thoughts on that definition. The one thing I was trying to deal with is things like, for example, what we talked about before, public records. And I know that's somewhat of a different conversation because I know we were waiting for that amendment to see what happens. But when I said, you know, the absence of which would cause harm to the client, if it's public record and we have an original and it's old and we're way past our 6-year period and we can't find the client to return it, but it's in the public record, you know, can we rely on a definition like that to allow us not to have to keep an original? That's one thought.
Yeah.
The other thought I had, which I'm throwing out as an idea, and I don't know if it'll get traction from you guys, but I'm just going to throw this out, is would it be too burdensome to change the rule to say that lawyers have an ethical obligation, I mean, actually impose an ethical obligation to let go of originals? Hang on, I'm sorry, we've got a fire truck outside. I couldn't hear myself, but no, just to say at the close of a case, when we're done with a transaction or a lawsuit and we're closing the case and putting it in our 6-year storage, what if we impose upon ourselves that we at that time have to get rid of any originals that we have in our file? And if we want to have an original ourselves, we can do what we talked about earlier. We can have a second set of originals.
Right. So I think my thoughts, I think these are things that I was swirling around with myself. So I appreciate hearing this because it's kind of reaffirming in that way. The public record thing, why I didn't put something specific to public records, and maybe we need to put this in here because you're raising the question too, was that I feel like when something's a public record and the public record is sufficient, that the document in your possession is not legally significant anymore. That was kind of my thinking.
Agreed.
I don't know.
I agree.
I think we agreed on that before at a previous meeting, but Brian, I thought that you were a little hesitant to accept that position pending this other rule amendment.
Yeah, and I think I guess if I was, then I disagree with myself before.
Okay. Well, I mean, is there anybody that that has an issue with accepting public records from the definition of legal significance? Because I think I'm guessing we're all in agreement that that's appropriate.
Yeah.
I'm in agreement. I wanted to throw out there, instead of saying the absence of which would cause harm to the client, I wonder if we could even narrow it further to, I'm trying to think of the best way to phrase it, and I'm sure I haven't come up with that, but basically to nullify its legal effect. If you don't have the original, it's no longer effective legally. The cause harm to the client, I think about, okay, I've got the original deed in my file, but the client can go get a certified copy at the Register of Deeds. Well, they're going to have to pay for a registered copy. Is that harm?
Hell
You
no.
know,
Warren.
was that a no?
I think it was a hell no.
No, it's a hell no. Hey, Warren, I told you you weren't supposed to cuss.
Yeah,
It's Christmas.
letting everything loose today. I'm sorry. I'll be
First day
quiet.
of Hanukkah. Anyway,
That's a
yeah,
soft one. Yeah.
I see what you're saying. I see what you're saying, Christina. And yeah, I think the public record thing, to me, it's, again, it's really focused on sorry, we get call notifications from like all different angles right now. The public record thing, I feel like is that issue that, the document, if it's available in the public record, I guess I'm trying to think of the situation where you have a document that's been filed, there's a certified copy that's available, etc. It's public, but the original is what you need to effectuate the client's goals. I can't imagine that. I guess it's the one thing that I'm kind of wondering about is like, if it's like something that gets attached as an exhibit, like if you have an original will and it gets attached as an exhibit, which enters the public record, that doesn't necessarily make it the will eligible for destruction. Right? I'm not trying to speculate and make up something that's not realistic, but
Can I make a suggestion? This might be why you couldn't find a definition in any other state about this, because there's too many ways in which you can imagine something might be document of legal significance. Trying to define it too much further, I don't know, it might be very difficult. That's why everybody assumes we're really just talking about wills.
I have two examples of things. Survey, I have an original survey of a client. Now you can have it recertified, right? The stamp by the surveyor. And we have passports sometimes of clients. Now that's for domestic clients. And by golly, I want those out of here as soon as possible. But there are times that we've had original passports and surveys. So those are, and I agree that to put in there, as I think Andrea was saying, to get rid of, we have an ethical obligation to get rid of these at the end of representation. And I think that deals with those.
Well, I was going to say, Andrea, to that point, I have advised folks to get rid of that. They have that obligation already under 116D. That rule 116 is the termination of the representation rule. 116D basically says upon conclusion or termination of the representation, lawyers have to take steps that are necessary to protect client interests, including, giving reasonable notice, sufficient time to move on to new counsel, and returning all client property and any unearned fees. And so I've always interpreted client property being those original documents that when you conclude your representation, you need to give back what is now client property, that will, that document that is, the absence of which harms the client. And so, but it's not always very clear. And so I think to your point, I think this is an opportunity to say that, and make that connection. I think you're right.
I think we need to make it clear, because when you say property, even though technically that means documents, right, it's not a trigger for people. And I think if we all learned that we have that responsibility, it would save us a lot of headache down the road. We might not be able to save what we've done in the past, but prospectively, I think if everyone's doing that, it's going to be a lot easier on everybody.
All right, I'm going to add that. I think I think we can just add that to make it clear. I know I put in here that, you know, it's preferable to return the property to the client when you're dealing with this law practice, you know, and all that. And that kind of addresses the whole thing that, okay, you haven't returned it, you just have it. So now what do you do with it when you're trying to close up shop? So we'll kind of get to that part a little bit later, but I'll add that this part that we're discussing here, that we lawyers have a duty to return those originals upon the termination of the representation, the conclusion of that representation. And as for the public records thing, I mean, I think we've perhaps hit some things where it's like maybe I don't know if this is helpful or not, but I feel like we're reaching the conclusion that generally speaking, most times that a document becomes a public record via registering with the Register of Deeds, wherever it goes, that registration as a public record will make the original lose its legal significance, but not always. And so that might be just another factor in determining really whether a document has legal significance. To me, sometimes it's going to be clear. A lot of times it might require a call to a colleague or to ethics staff to say, hey, what do I have here? Should I keep this? Should I deliver this? You know, and that's the part where, because it becomes so subjective, to Warren's point, why other folks don't define it, is because it really is dependent upon the circumstances, which is not helpful. We'd like to define something, but it may be one of those things that's just too difficult to define.
So I'm going to stop for a minute and just let everybody know. I'm looking at the time. We've got we're 6 minutes until 4 o'clock. And Brian, on my calendar, I saw that you had blocked out an hour. Is that correct?
I did. Yeah. This was a very fast hour.
It seems like that.
I'm shocked.
We're
just having so much fun talking ethics. You just lead such a fun committee.
Yeah.
I have another Zoom that starts at 4 today. Everybody trying to pack everything in before the holidays start.
I have a hard out at 4 also.
Okay.
So I guess because we only have now 5 minutes left, what do you think, Brian, would be a good way to wrap this up and then take up this discussion another time? And in the past, we've talked about having a 90-minute session.
Yeah. And
which is not realistic between now and the end of the year, but
yeah, no. But I'll how about this? What I'll do is we'll send out a poll to see if anybody's available in January. If we could get another meeting in before the January meeting, that's great. If we can't, so be it. But we'll send out a poll to see if folks can meet. We'll schedule for 90 minutes. And I apologize, I forgot that last time we did 90 minutes, and we should have done that this time. But I'm going to incorporate these additions into the draft that I have in front of me. And I'll highlight it to kind of show like these were the additions that we made during this meeting. So you can kind of tell them apart a little bit better. And I think I personally feel like we're heading in a direction. I feel good about the direction this opinion exists, where it's pointed, and the conversation. I feel like we're really close. And I'm wondering at the next meeting, if we go through the remaining parts and we're all on the same page, this might be something that's ready for publication. But in the meantime, like I said, we'll get everybody together. If there's something else that you read in this opinion and say, I really want to talk about this, I would suggest you send that to Andrea and I, and we can make sure that we highlight that at the next meeting and see if we reach a conclusion, at least at this stage, at the next meeting.
Okay, and I have a request. If you guys think this would be helpful, but because there's so many opinions that we have embedded in here, when you give us our working copy next time, can you just highlight what we've already agreed to?
Sure.
So that whatever's not highlighted is what we need to focus on. Because I know we've got some things we've already agreed to. We don't need to spend more time reviewing that.
Right. No,
Okay.
absolutely. This has turned into an incredibly complex opinion and issue that I think when we all first looked at it, it was like, well, no, we just apply the rules. But I have to say, I love the thoughtfulness that's going into this. I think we're really working towards a very helpful opinion to lawyers. So
Yeah.
we'll continue on.
All right.
I
And
agree.
thanks
I agree.
everybody for being willing to stay on this subcommittee.
Thanks.
All
Y'all.
right.
Thank you.
Thanks, guys.
Merry Christmas, Happy New
Thank-
Year, everything.
Same to
Happy holidays,
everybody.
everybody.